of and or giving effect to the orders and declarations issued by the Constitutional Court in Constitutional Petition number 45 of 2016 between the parties hereto are stayed until disposal of applicants intended appear. Who are you to go against the order of the Supreme Court? Chairman and honorable members, that is the position of the law. And if in a case it is not, if we don't accept, personally I think I would even be prosecuted to give a reason that they will not have jurisdiction. Chairman and honorable members, I feel otherwise, as of now, we have jurisdiction of one of these things. So there is no matter that we will find again for constitutional information. Yes, sir.
Thank you so much.
The fight, I think, the issue of Chiza error. The issue of Chiza error. First of all, it did not arise from the ruling of this court this morning. This was a different matter. Court never made the rulings in regard to Chiza error, and the court determined, pronounced itself, and it is functions of this. So there is no way how this court can again turn on the same point of law to interpret what happened in that ruling.
Bwowe Ivan for the record, and in rejoinder, I'll be brief. The beauty about attending class is that some learn and some do not learn, even when you are attending. Council Kalibala, Council Mpanga, Council Kalua, and Council Lukwago went into further detail about the constitutional provisions, the questions vis-a-vis the UPDF Act and the Constitution. I am disappointed that they might not get a financial benefit of that, but they offered it free of charge for us all to hear and listen. The actual fact that we sit here and says that does not raise a question, that is a question, is the actual reason as why we should be in the Constitutional Court on such matters pertinent to this matter. I also want to state, in general rejoinder, that it's not the duty of the prosecution to frame questions that we want the Constitutional Court to address. And nor is it the duty of this Honorable Court, with all due respect, to usurp powers of the Constitutional Court under 137 to interpret questions posed by the parties. I also want to state unequivocally that there are two legs within the Constitutional Court. If it may please you, I will substantiate on the two legs. On the two legs, there is one where the court deems it fit to raise a constitutional question. That is one leg. And in the wording of the Constitution, they use the word may. I believe that you as officers of the UPDF understand command, order, and all that. The second leg of that Constitution, Article 137, 5B, gives latitude to the parties to escape the tyranny of a court, tribunal, or a disciplinary committee by allowing the parties to pose a constitutional question. And we didn't move under the other leg one. We used leg two to protect and defend the rights of the accused person. And that leg In the Constitution, it says shall. It is coiled in mandatory terms. The Supreme Court has been in position to guide in a number of authorities about the coiling of the Constitution and the word shall and may. And the framers of the Constitution, of which Dr. Ageesigika, one of the accused person was, is very clear and instructive. So it's our duty to ask that the professional UPDF under Article 208, the profession and professional soldiers should respect the command and the supremacy of the Constitution, of which we are all here to defend. Members of the General Court Martial, I also want to mention that when the prosecution wants to phrase its own questions, it shall present them before the Constitutional Court. We have framed ours, and we are saying this matter warrants a constitutional interpretation. Members of the tribunal, I do not understand the obsession with the Kabazukura case. My senior has already alluded. I said the General Court Martial, Tribunal, or any disciplinary committee. And with the word court, if it appeases your ears, I shall leave them that. Professionalism means respect to the rule of law. None of you will be hurt, or there is nothing for you to lose if you refer our questions to the Constitutional Court. And in the way, counsel lied to this honorable court by saying that this court's hands are not tied. Actually, they are tied with chain and shackles. And I'll address in broader perspective about the MOU talked about. That MOU is alien to us, and it's not anywhere within our knowledge. All that we are so sure of, Article 79 of the Constitution only gives powers to Parliament to make laws, and also has a condition that no one else can make laws that have force in Uganda. Whoever that MOU might have had his own wishful desires, and that's not our problem. Our problem is that the law of the land must be enforced the way it is to the latter. And also, in the most severe, I want court to take judicial notice under the Evidence Act, as taught by Senior Kalibala, that even in the most cases of Jamil Mukulu, there was an extradition from Tanzania. As to whether the accused person did not enjoy that benefit is also another phenomenon we are about to explore. I also want to state that the issue of impartiality has been largely misunderstood by my colleagues. It's not about the members of the court, no. It's about structural issues rooted in the UPDF Act vis-a-vis the Constitution of the Republic of Uganda. We do not have any desire to impute the credibility of the members of the panel, and we have less appetite for that detail. I also want to state that, having said so, these are our questions as to whether they desire to make submissions challenging any of the interpretation. Unfortunately, none is qualified. None of us is qualified to authoritatively do that, save from the Constitutional Court. And trying to do that is violating and usurping the powers of the Constitutional Court and molesting and defiling the Constitution of this Republic. The idea that we quote Kabaziguruka and leave other cases that have been decided and not appealed is appalling, and should be the duty of the officers of the UPDF to maintain the stature or the desire for the UPDF to be a professional army. And finally, when a matter arises, when a constitutional matter arises, it has to be referred for interpretation. Otherwise, again I state, none of us is qualified to interpret the Constitution. And another rider is failure to respect the interpretation of the Supreme Court, also tantamount to violation, molesting, raping, defiling, and abrogation of the Constitution of the Republic of Uganda. It's our desire that we do not want the UPDF under these institutions, most especially the General Court Martial, to trade and trend that way. Again, we do not know about that MOU being quoted. We do not know it as under the laws of Uganda. We also do not, we are certain that it did not conform to Article 91 of the Constitution of the Republic of Uganda, and whoever made it can as good as use it to light a fire and a charcoal stove for their own benefit. Thank you so much.